On the 28th of May 2010, the ICAC executed a search warrant, during which I was asked to give the ICAC investigators my original academic qualifications, including my original university testimonies. The following is a part of the search warrant video.
Number 29 is a bundle of documents regarding your qualifications and postgraduate
They're
research
my
program.
originals.
Yep, they're going to be 100% safe with us, okay? What happens when we get back to the office, we lodge them in the property section, and every individual item, as I've described it here, is registered under that number and kept locked away in our property section, okay? So,
Prior to the ICAC private inquiry on 15 December 2010, the ICAC principal lawyer told me that all my academic qualifications were irrelevant and that I no longer hold these qualifications, and for this reason I would not be questioned about my academic qualifications at the ICAC inquiries. I was never asked about my academic qualifications at the ICAC inquiry. However, I did my best to explain to the Commissioner that I hold the relevant academic qualifications to carry out the work I completed for the medics clinical trials. When writing my submission to the ICAC, I never wrote about my academic qualifications, as I was told they were not relevant. I did, however, write about my work experience relevant to the clinical trial work I completed at the two hospitals. In June 2014, I required my academic qualifications to enrol into a course, and after a request, the ICAC gave me access to documents seized during their search warrant. When I arrived at the ICAC and began inspecting my documents, I found that a large volume was missing, including my academic qualifications. I inquired about the missing documents, especially my university testimonies. However, I was never given a proper answer. On 26 September 2014, the ICAC was issued a subpoena to produce my testimonies in the local court. The following is the evidence given by the ICAC solicitor at the local court in response to the subpoena.
High school certificate record, which I understand has been raised between. Perhaps my friend can.
Yeah, we saw it, Your Honour, on the video of the search when they took down Miss Lazarus's academic records from the wall. They looked at her academic records, and if my memory serves me right, they said, "Oh, this is." One of the officers doing the search said, "Oh, this is very impressive here, Sandra." She said, "Yeah, but will I get my academic records back?" Now, if we can play that search, which is an exhibit in these proceedings.
I don't recall that. I'm not doubting you, though, Mr. Neville. I just don't recall it. But what is the forensic purpose for having that academic record? And secondly, isn't that something that's within your? I mean, an academic record is something that you can easily acquire. There's nothing particular about the document. The records are readily available to you from another source.
Yes, but that's not the point, Your Honour. The point is these were documents seized under a search warrant by the ICAC, identified in the videotape, and of which the IC officer said to Sandra, "Yes, we'll give these back to you, Sandra."
I understand that, but what's the legitimate forensic purpose?
It goes to
in relation to these proceedings.
It goes to her qualifications to do the tests that she was trained for. It also goes to her good character and whether a woman, Your Honour, of Miss Lazarus's academic standing would then throw all that away for the purpose of trying to take money from the Health Commission of New South Wales. It goes to a substantive matter.
But these documents, these documents are records, and the records are readily accessible to your client in any case. I mean,
she'll have to go to university and get those excuse me, Your Honour.
They're original documents seized by ICAC.
Yes, I understand that. Yeah, we understand that. They're original documents. I think Your Honour understands that they're original documents. But why should the defendant have to go back and get them when the ICAC have them, and they are the prosecuting authority in these proceedings? And that goes to her good credit. It goes to her academic abilities to do the test, because remember, Mr. Neuron gave evidence that he didn't think she was trained well enough, and I think Dr. Waters was saying, "Oh, it's just rubbish, she doesn't have the qualifications." And there's also the big issue that my friend has raised about whether her PhD, and evidence has been given by various doctors about the PhD. And $158 to replace them, I'm told. Yeah. So they're the matters I put, and I cannot see, for the life of me, Your Honour, why the ICAC would be objecting. Like, first of all, but I could call Miss Lazarus in her opening, if Mr McElwain wants to hang in here, and I could ask her about why the academic records are important to her and in these proceedings.
I think I could shorten the matter, Your Honour. My instructions are that in relation to documents seized under search warrant, that there is no document seized that would constitute a university academic record. Is that correct? There's nothing to produce.
In that case, Your Honour, I have to call upon, and I don't want to do this, call upon the exhibit in regards to the search of Ms Lazarus' premises, but I don't think we've got the facilities to play it, but they were. And the reason for that, Your Honour, is because, and why I remember it, Ms Lazarus has been complaining all along about not getting her academic records back. And that's why I picked it up and made a note of it at the time they took the academic records, because she can give this evidence in the box, Your Honour, but I give from the bar table, that she went to the ICAC and asked for them back, and they said, we don't have them anymore, or we don't have them. So it's pretty disconcerting in a case of so serious a nature as this, that just mere academic records is being opposed by the ICAC, their return to the rightful owner.
Just wait. I'm just trying to work out what the legitimate forensic purpose is that you're raising. I assume your client's going to get in the witness box.
Indeed.
And you were going to lead from her, or she's going to be cross-examined about her academic history.
Yes.
And her whatever qualifications she has.
Yes.
And you consider that this is important.
Yes.
And you haven't applied to have those provided to you by any university that she's attended. Rather, you're wanting to have an original document that you say that ICAC has in its hands to prove that in fact she has these qualifications.
Yes.
Even though the records are held by whatever university she attends.
Yes. The thing, they're her original academic record.
I
That
know,
is it. Yes, Your Honour. That's it. That's the case. And it also goes to the issue of whether a person such as the defendant, spending all those years studying, doing academic things, would then want to throw it away to steal anything up to $800,000 or $600,000.
all right, well, that'll be a matter for submissions, obviously, but Mr McElwain has indicated that those documents just are not available.
For documents seized under an official ICAC search warrant to go missing is an inexcusable offence. Since the seized documents were not itemised individually, there is no way to determine if other documents that the ICAC seized during this investigation have also gone missing. As an investigative government organisation, the ICAC has absolute responsibility for documents seized in relation to their investigations and must ensure the utmost safety of these documents. It is neither just nor fair to prosecute an individual when evidence has gone missing. It is my strong opinion that the ICAC refused to give me my academic qualifications in order to reduce my credibility in comparison with the medical practitioners from the hospitals. During my local court proceedings, I was asked about my academic qualifications. I listed these academic qualifications. I did not state from which institutions I received the academic qualifications and which institutions I am currently enrolled at. Since the ICAC public inquiry in 2011, I have tried to enroll at a number of universities to continue my studies. However, the ICAC contacted these institutions and stopped my enrolment. There have been occasions where I have enrolled, and when the university is informed of the ICAC inquiry, the university becomes disgruntled and discriminatory, and even at times has informed me that I can only communicate with one staff member and no other staff member or students. This abuse reaches such a level that I am eventually forced to withdraw from the university. The emotional and psychological trauma from the ICAC contacting these institutions and their appalling behaviour towards me has caused me great suffering. As a result, I was immobilised and could not bring myself to answer the question regarding my institutions of study. This in fear that the ICAC would once again contact the institutions and destroy my studies. At the local court proceedings, I requested my academic qualifications again and stated that even the photocopy would suffice, but no answer was given and no order was made by the magistrate to have my academic qualifications returned to me. In 2003, I was awarded a Bachelor of Science, and in the same year I was awarded a Master of Computer Science. In 2006, I was awarded a Bachelor of Medicine, a Bachelor of Surgery. I'm currently enrolled in the postgraduate program for Theological Studies, a Master of Surgery, and I'm currently enrolled with the Royal College of Surgeons to complete examination. In 2005, I published a chapter in a textbook in the field of medical informatics. I taught at the University of Western Sydney for approximately 5 semesters for the practical component of computer science subjects for first, second and third year bachelor students. I also taught at the Nepean Medical School, the University of Sydney, for medicine students for approximately 2 semesters for the practical component of the subject haematology.